My Lord, for the record and for the interest of those who are transcribing the proceedings, my name is Elisha Ongoya. I appear for the first petitioner applicant, His Excellency Rigathi Gachagua, Deputy President of the Republic of Kenya. My Lord, I stand here to canvass the Deputy President's application dated 18th October 2024, which in the main seeks that you have implementation, or put appropriately, further implementation of the resolution of the Senate made on 17th October 2024. Allow me to then also record that we have some written submissions that were filed, and I think it's good practice to draw the court's attention to them so that the record confirms that they are part of the record. We have filed some written submissions on 22nd October 2024. We adopt and reiterate the contents of those submissions. When we retire, we urge you to have a look at them. But we also filed some additional written submissions on 28th October 2024. Both of them are entitled Petitioners' Submissions on the application dated 18th October 2024. Let me move into the substance of what I want this court to consider this morning. And I want to make some overall observations, my lords and my lady. I prefer to look at this case in this court as an opportunity for our constitutional order. Whereas I know that there may be Kenyans out there interested in this matter, looking at this moment as a challenge to our democracy and a challenge to our constitutional order, I bear a message of hope. I want us to look at these proceedings as an opportunity for our constitutional order. So the challenge for me, my lords and my lady, is how we shall seize and use this opportunity. I look at it as an opportunity for our governance institutions. My lords will remember the words of the late Justice Chunlal Magwanda's Madan in that famous case of Githunguri versus Republic, where he urged Githunguri to run unto the hills, face east, and thank his gods that Kenya is a country under the Constitution. I see this as another opportunity. I beseech this court to urge His Excellency Rigathi Gachagua to run to the top of Mount Kenya, face east, and tell the world that Kenya is a country under the Constitution through the opportunity presented by this case. I see this case as an opportunity for the judiciary, and I'll be elaborating on this point in a short while because of the behavior of other organs of government in the recent past. So I see this as an opportunity for the judiciary. I see this case as an opportunity for righting wrongs and not for perpetuating wrongs. I have had the privilege of participating in these proceedings from the National Assembly, through the Senate, through this court. And I thank God and thank my client for it, because out of 50 million Kenyans, I have done nothing special to deserve this opportunity, but this somehow fate has conspired to give me an opportunity to participate and witness these events from the front benches. What this case has taught me is just how perilous we stand as a country if we depend on our legislative and executive institutions, and very recently, our constitutional commissions. Our remaining beacon of hope, my lords and my lady, is this judiciary. I have one question for you, my lords, my ladies. Will you drop the ball, or will you hold the ball to the finish line? A brief history of what you will find in our amended petition, by way of paraphrasing, is that on 18th October 2024, this country witnessed an unprecedented hurry by our executive, legislative organs, and our constitutional commissions to beat our constitutional order. I'll demonstrate this shortly. On that day, 18th October 2024, we witnessed an unprecedented hurry. In fact, I would have thought, speaking for myself, that our country has become super efficient. But I discovered no. We are still waiting long to get our national IDs. We were still waiting long to get our passports. We are still queuing for long in our hospitals for health services. That this unprecedented hurry was for a specified project to beat our constitutional order. And why do I demonstrate this? A process for which the Constitution of Kenya prescribes 74 days at Article 149, Clause 1 of the Constitution was truncated and executed in less than 6 hours. Clearly, we may have varying definitions of the word hurry, but we can build consensus that this one is undisputedly unprecedented hurry. Why did the makers of our Constitution prescribe 24 days maximum in Article 149, Clause 1? Different analysts may give it different interpretations. I beseech you to find, whatever the scope of interpretations, the following fit into them. Number one, it must have been to give the process optimum transparency. Number two, it must have been to give the process optimum accountability. Number three, it must have been to give the process procedural fairness. Because whereas we know that justice delayed is justice denied, we also know that justice hurried is justice miscarried. And finally, it must also have been to give public participation in the process under Article 149, Clause 1, some chance. Allow me to submit at that juncture from the very outset that the process undertaken by the President of the Republic of Kenya, by the Ethics and Anti-Corruption Commission, which was mentioned in the President's communique to Parliament, to the National Assembly, by the IEBC, that was also included in the President's communique to the National Assembly, and by the National Assembly itself, did not even pretend to have an iota of public participation. Even the pretense of public participation was now taken away. We will demonstrate to you that the process between 1st October and 17th October, the process between 1st October, when a notice of motion was given in the National Assembly, to 17th October, when a resolution was taken by the Senate, had pretenses, half-hearted no Kenyan was given a chance to give any thought on whether or not he is suitable to be deputy president. No member of the public, no memoranda was received, no meeting was called anywhere for anyone to give any thoughts, no email address was given to be crushed by Kenyans, as we now know Kenyans can do it. Completely no pretense at public participation. I'm emphasizing these points, my lords and my lady, to demonstrate the point I made earlier, that we have now been taught how perilous it is for us to rely on our executive institutions and our legislative institutions and our constitutional commissions as defenders of our Constitution. We are now left with only one institution, this judiciary. I don't know where that noise is from within here. I think if they are doing renovations, they may be told that this is so important a day for renovations. We may defer them to another day. And let's face it. Let's face it. The process of 18th October 2024 took 6 hours as a deliberate scheme to defeat each of the principles and values of good governance I have alluded to: transparency, accountability, procedural fairness, and public participation. Who did these violations? We are also here to call people to account. Who did it? Between the time we left Senate around midnight, between the time Senate closed business around midnight of 17th October 2024, and the time we woke up to the presidential communique of 18th October 2024, in that night, the Bishop Oginde-led Ethics and Anti-Corruption Commission is documented in the President's memorandum to have received, processed, and given a clearance to Honorable Kithure Kindiki. That night. My lords, history is important, and I may not remind you why our Constitution prescribes that our presidents be sworn in during the day. We were all adults, we know where that comes from. It's one of the most autochthonous provisions of our Constitution. And therefore, when things happen in the night, we have reason to have our antennas high. Between the time Senate rose on the night of 17th October 2024 and the time we woke up in the morning of 18th October 2024 to the President's communication to the National Assembly, we were told that the IEBC, which we now know is not properly constituted, has no commissioners, had purportedly cleared Honorable Kithure Kindiki in the night. I'll not say much about KRA because I think KRA can work overnight and we will not complain. But it was that memorandum. The other culprit was the president himself. The president of the Republic of Kenya undertook these clearances overnight and in the morning had a clear proofread memorandum. Exceptional efficiency, we celebrate that. To Parliament. Then the National Assembly itself. Now this is curious. The National Assembly itself had called a sitting prior to the resolution of the Senate. The sitting was called prior to the resolution of the Senate. To sit on a day, ordinarily not a day of sitting of the National Assembly, to process a resolution of Senate it had anticipated, the removal of a deputy president from office and processing clearance or approval of another deputy president. We sit here as judges, we sit here as court assistants, we sit here as advocates representing various parties. I don't know who among us, once we take away the cloaks of the official roles we play, was proud as a Kenyan observing these events as they happened. I don't know who among us was proud now putting on the cloak of citizenship to watch these events unfold at that pace. Fortunately for us, my lords, my ladies, we have a judiciary of Honorable Richard Mwongo that arrested this process in its tracks to give the Constitution a chance to roar. In the far corners of Kerogoya. Fortunately for us, we have the judiciary of Honorable Chacha Mwita, His Lordship, that arrested this process to give the Constitution a chance. Today, you sit and I stand before the judiciary of Honorable Ike Ogola, Honorable Esim Rima, and Honorable Dr. Frida Mugambi, that has been invited by the respondents to undo that chance that the Honorable Mwita and the Honorable Mwongo gave the Constitution. We don't begrudge them for that invitation. Because under Article 48, they are entitled to come here and make that invitation. Our question is whether the judiciary of Honorable Ogola, Honorable Mrima, and Honorable Dr. Frida Mugambi will be baited by that invitation. That's our only question. Throughout these proceedings, we shall be looking at you in the eye to ask, will you fall for this bait or will you stand for the Constitution? Having laid out our broad attitudinal view of this matter, allow me to address you now on the law and the jurisprudence of conservatory orders. In terms of textual prescription, in terms of the prescription of text of the Constitution, we will find accommodation for conservatory orders in two aspects of Article 23, Clause 3 of the Constitution. Article 23, Clause 3 says, in any proceedings brought under Article 22, a court may grant appropriate relief. So we find accommodation of conservatory orders in the use of the phrase appropriate relief, because appropriate relief is wide enough to accommodate anything under the sun that is necessary to give effect to a right, fundamental freedom, or I dare say, any other provision of the Constitution. The second accommodation is in paragraph C of clause 3 of Article 23, which says, in any proceedings brought under Article 22, a court may grant appropriate relief, including, say, a conservatory order, expressly. I'm a bearer of good news that in determining whether or not to grant conservatory, to confirm these conservatory orders, my lords, you need not look further than in the files before you. I'll demonstrate you shortly. Just by looking at the files before you, you will see why you must confirm these conservatory orders. Let me go there. Allow me to address the brief issue of your jurisdiction over this matter from the files before you. I would invite you, when you retire, to look at the ruling of your brother Justice Mwita of 15th October 2024 in petition number 550 of 2024. When you look at that ruling, I would invite you to look at page number 7 of that ruling. There is a paragraph 7. The way that ruling was processed was that each theme the judge addresses by beginning with paragraph 1 to the last, then another theme, paragraph 1. So you'll see a lot of paragraphs 1, 2, 3, then it ends, and you begin paragraph 1 again. So you look at the paragraph 7 at page 7 of that ruling of Chacha Mwita in petition number 550 of 2024. For the benefit of this court, for the benefit of everybody who is listening, Honorable Chacha Mwita said the following things at paragraph 7, that the petitioner also argues that constitutional imperatives in conducting public participation were not met. The claim falls within the scheme of Article 165(3), so that this court has jurisdiction to interrogate whether any of constitutional processes said to have been conducted under its authority met the constitutional threshold. The judge has already established that the argument on public participation raised by the petitioners falls within the jurisdiction of this court under Article 165, Clause 3. Then, paragraph 9 of that ruling on the same page. Justice Chacha Mwita holds, first he observes that the first respondent has pushed an argument that this court has no jurisdiction to hear a matter arising from impeachment of the president or deputy president on the basis of Article 165(3)(c). Then he reproduces the provisions of the article verbatim. I wouldn't want to regurgitate that because you'll read it. He proceeds now to argue that Article 165(3)(c) is in relation to the process of removing the president or a deputy president from office on grounds of incapacity. This process is initiated for purposes of investigating the president or deputy president's physical or mental capacity to perform functions of that office. And here's the clincher. This is a distinct process from that of impeachment in Article 145 as read with Article 150. Article 163C excludes jurisdiction of this court over the process undertaken in accordance with Article 144 and not Article 145 as read with Article 150 of the Constitution. Honorable Chacha Mwita has made a finding that this court has jurisdiction over a matter or a process undertaken under Article 145 as read with Article 150 of the Constitution. If you turn to page 9 of that same ruling, of Justice Chacha Mwita of 15th October 2024, in petition number 550, page 9, you'll find another paragraph 4. I think I explained why these paragraphs run back and forth. Paragraph 4, he says, I'll read paragraph 4 and 5, so for full effect. Paragraph 4, Article 145 lays down the procedure to be followed in cases of impeachment and the timelines for doing so, including affording the person an opportunity to be heard on the charges. I have considered the constitutional provisions on impeachment and read decisions from the Supreme Court and the Court of Appeal, which are binding on this court. These decisions have laid down the position that it is important to let the impeachment process run its course, after which the court would have a look at any complaints on violation of either the Constitution, the law, or fundamental rights, including processes. After which, the court would have a look at any complaints. He's again asserting the jurisdiction of this court at this stage. Then, I would also invite you to look at at page 10 of that same ruling. At that same ruling. And this is the clearest warning that Justice Chacha Mwita was sending to the National Executive and the National Legislative Institutions, Parliament. At paragraph 9 on page 10, he observes, in other words, constitutional processes are not about dashing to the finishing line, which is what they were doing. It's not about that. They were being told what you are doing is child's play. And we are not here about child's play. We are here about the Constitution. He says they have constitutional imperatives that must be complied with. And if not, such infractions will not be out of reach of our Constitution. He completes by saying, where there is an allegation that fundamental imperatives in the Constitution have not been complied with, which is the allegation that you have before you, my lords, my lady, the affected person, my client, His Excellency Rigathi Gachagua, has recourse to court, and the court will have to determine whether the state organ complied with the Constitution or the law. Has recourse to court. I began by saying we need not look further than in the files before you to assert that these orders have been confirmed, and I'm beginning by confronting the unfortunate allegation of lack of jurisdiction that has been filed on behalf of the person who was nominated to be the deputy president and who is supposed to uphold the Constitution. At paragraph 10, he gives the most enduring philosophical statement of page 10, paragraph 10, page 10. In that respect, our Constitution offers both hope and promise. Hope that the institutions it has established will comply with its fundamental principles. We now know that that was hope against hope. And promise that the Constitution is supreme, and any act or omission in contravention of the Constitution is invalid. In other words, it does not matter how far the process may have gone, since no action is beyond the reach of our Constitution. My lords, I want to speak the truth here. In the face of these pre-existing rulings in these files, you will hear arguments here of non-justiciability of this dispute, political question doctrines, things that have been fished in a cut and paste manner from old American jurisprudence into a transformative constitution of the 21st century. I mean, that's unfortunate. I am hoping that once I'm done with this, those who came to court carrying those arguments of political question doctrine, non-justiciability, will find favor in abandoning them to save us some time. At the same page 10, you'll find another paragraph 1. When I tell you the judge was starting paragraph 1 at every new issue. He says, Article 2, Clause 4 of our Constitution is not only the hope, but also the promise of our Constitution that we must abide by constitutional dictates, for any act or omission in contravention of this Constitution is invalid. That's what the judge is telling us. When you look at the files before you, my lords, you'll also find the ruling of your brother, Justice L.N. Mugambi, in petition number 522 of 2024, His Excellency Rigathi Gachagua versus the Speaker of the National Assembly and others. Another file that is before you. At page 9 of that ruling, you will find paragraph number 34. In that paragraph, the judge observes, and that was when he was delivering the ruling to send this file to the Chief Justice to empanel the three of you to sit. He says, Article 165, Clause 3, Paragraph B or D of the Constitution has been delineated by Article 165, Clause 4 as constituting areas from which substantial questions of law might arise to require composition of a bench. He then goes ahead and reproduces Article 165, Clause 3, B and D. He's saying, before he sends this file to the Chief Justice to empanel a bench, he must satisfy himself that the dispute in question falls within Article 165, Clause 3, Paragraph B or D. And he made the determination that the dispute falls within Paragraph 165, Clause 3, Article 165, Clause 3, Paragraph B and D, and send the file to the Chief Justice to empanel the three of you. The three of you are sitting on this bench on a finding that the court has jurisdiction. In the absence of that, the dispute would have been outside the ambit of Article 165.4 for empaneling of a bench. Then, my lords, let me not just take you through the jurisprudence of others. Then there is your own jurisprudence as this bench. Days ago, on 16th of October, 2024. 13 days ago, the three of you my Lord Justice Ogola, my Lord Justice Mrima, my Lady Justice Frida Mugambi, delivered yourselves on this question of jurisdiction. In that ruling, in petition number 522, as consolidated now with the others, in that ruling that you delivered on 16th of October, at paragraph 83, you observed that at the moment, that was at that time, this court is being called upon to anticipate the outcome of a process yet to be completed. The application at this point is premature and anticipatory. In any event, should the petitioners not succeed before the Senate, they still have an opportunity to approach the courts. The applicants cannot therefore say they have no remedy. Now, I was asking myself as I prepared, I'm imagining you now telling us, no, you have no jurisdiction. Having told us this, my Lord, how will you look at each other? How will you look at us? You told us yourselves, go to Senate. Once you have finished, come here. Then we come here and you agree with my friend Dr. Mudomi Thiankolu, these are political questions and therefore we cannot deal with them. These matters are unjusticiable. How basic decency militates against at least the three of you, saying you have no jurisdiction. I respectfully submit, my lords, my lady. You observe that paragraph 85, that this court, and I was asking myself, what does the word this court mean? This court means two things. You said, this court has unfettered jurisdiction to check the constitutionality of the process at whatever stage. As such, we are certain that the petitioner's rights are currently well guarded and none of the petitioners stands to suffer any prejudice. You assured us that you have unfettered jurisdiction, that's what we used, jurisdiction, to check the process at whatever stage. I've said the word this court, I understood it to mean two things. One, to mean the High Court, because you are talking about this court. I don't think you had forgotten you are judges of the High Court. So that when somebody comes and says, we ought to have gone to the Supreme Court, they must also justify to you why you are using the words this court in this context. And number two, it means this bench. The three of you sitting here as a bench. You are now this court in this matter. You have unfettered jurisdiction to check the constitutionality of the process at whatever stage. At paragraph 87, you reiterated that you are exercising judicial restraint in order to accord constitutional entities the latitude to deal with their mandates. But then you said, we however clarify that courts can and ought to readily intervene in ongoing processes before any entity in the clearest of cases where there is evidence of flagrant and gross violation of human rights and fundamental freedoms. I began by telling you, the most flagrant is the happening of 18th of October, 2024. The most undebatable. The National Assembly received a nomination of Honorable Kithure Kindiki from the President. The National Assembly had in its face Article 118 of the Constitution. In its face. I'm sure some members are sitting here of the National Assembly. They had in their face Article 118 of the Constitution. That article continued to pronounce itself because Article 259 says the law is always speaking. So this article was consistently speaking to the National Assembly. Consistently speaking that Parliament shall facilitate public participation and involvement in the legislative and other business of Parliament and its committees. The law continuously spoke. The Speaker called the House Business Committee. They met. Article 118 was speaking to that committee that you shall facilitate public participation and involvement in the legislative and other business of Parliament and its committees. That committee turned a blind ear to this speech by the Constitution. They sat in plenary. Article 118, 1B was speaking that you will facilitate public participation and involvement in the legislative and other business of Parliament and its committees. The plenary turned a deaf ear. 2, this dictate. The most blatant. I want to ask how we cannot stop the confirmation, the assumption of office of Honorable Kindiki on this argument only until we argue this matter fully and settle it at the hearing of the main petition. I want to see. I'm a career learner. If you convince me, I can tell my clients they have convinced me. But I'm trying to imagine the kind of philosophy you will require to convince me. The 50 million Kenyans out there know. None of them was ever called upon to make any view, any thought on the suitability or otherwise of Honorable Kithure Kindiki to be the Deputy President of Kenya. They know. Then, at paragraph 90 of that ruling, you observed, in other words, this court is still able to grant a remedy even after the process in Parliament is concluded. You again asserted your jurisdiction. I want to conclude this aspect of my submissions, my lords, my ladies, by pointing out that it's a high time that we laughed out of this court anyone who questions the jurisdiction of this court in this matter in view of all these prior rulings in the files before you. Allow me to then briefly address you on the other aspects of issuance of conservatory orders. Again, I will not go further than your own earlier rulings. In your ruling of 16th October 2024, at paragraphs 62 to 71, you pronounced yourselves on the principles that govern grant of conservatory orders. We agree with each of those principles that you set out in that ruling without any modification. We agree with each of the principles that you set out in paragraphs 61, sorry, my apologies, 62 all the way to 71. I will address myself to only one aspect of those principles and invite my learned colleague, Mr. Macharia, to address the remaining aspects. This is where you allude to the case of Gatirau Peter Munya versus Dixon Mwenda Githinji and 2 others. If I'm not mistaken, this must have been the matter that was argued by my colleague, Dr. Tiankolu, some times back, so he would know it very well. It was among the first cases to deal with this matter. It's actually the first one in the Supreme Court of Kenya. You see, we celebrate Dr. Mudomi Tiankolu for contributing to this kind of jurisprudence. He observes, and I quote, that conservatory orders, consequently, should be granted on the inherent merits of a case, bearing in mind the public interest, caution of values, and the proportionate magnitudes and priority levels attributable to the relevant causes. I want to address myself to the inherent merit of this case and just on one aspect of public interest. In fact, let me just begin by putting aside the issue of public interest, by asserting as a principle, my lords, that I desire that you hold that the greatest public interest is upholding our Constitution. There can be no superior public interest attributable to politics or other considerations that would outweigh upholding our Constitution. In fact, that is my understanding of Articles 2 and Article 3 of the Constitution. Articles 2 and 3 of our Constitution provide that the greatest public interest is in upholding our Constitution. I can see my learned colleagues jittery. I don't know whether they want to raise an objection. Okay, thank you.
Not me. I would never raise an objection regarding you.
Thank you so much, my teacher and mentor, Professor Gedum Muigai. And I'm sure our other colleagues have taken cue from you, Prof. So that, my lords, when a petitioner raises a matter, like the clearest violation I have raised on what transpired on 18th, there can be no greater public interest than giving that matter a chance to be ventilated fully. I can't imagine of any. But having said that, let me now deal with how this petition meets the inherent merits test.
Just a minute. We had earlier on given a time allocation, which Mr. Kibe disagreed with and asked for 2 hours. We will give you that 2 hours and not beyond. You have done 1 hour.
Okay, let me now take 15 minutes to summarize the rest of the argument. Then we see how to wind up that. So let me address the issue of inherent merit, because that's my last argument. Then I can see what my learned colleague, Mr. Masharia, can mop up. We had gotten another indication, my lord, that we have the whole day. That's the last direction you gave before this one. So that's why your words, my lord. I'm sure the transcript will come out with those words.
That is, we speak as Africans.
Let me do the best I can in view of the new direction, because that has made me now to change my approach. Which can
Certainly, Mr. Ongoya, you didn't expect that we have the whole day. We had given directions on time,
yes, and
on your own authority of Mr. Kibe. He said you would want 2 hours. And we have agreed to that. So let's stick to the petitioner's side having 2 hours. Let
me give it my best. We'll deal with the eventualities. Allow me then just to refer to a few things. On your ruling of 16th October 2024, at paragraph 78, you observed, and I quote, "In sum, therefore, in determining whether a matter discloses a prima facie case, a court must look at the case as a whole. It must weigh, albeit preliminarily, the pleadings, the factual basis, the respective parties' positions, the remedies sought, and the law. In so doing, a court must be guided by Article 22, Clause 1, and Article 258, Clause 1 of the Constitution, which provisions are on the right to institute court proceedings whenever a right or fundamental freedom in the Bill of Rights has been denied, violated or infringed, or is threatened, or when the Constitution has been contravened or is threatened with contravention." Then you at paragraph 79, you observe, "Applying the above in this matter," petition 522 that is before you now, and without much ado, we are satisfied that the consolidated petitions raise constitutional issues that require further judicial consideration. You made a finding that the case has inherent merit. You could see it without much ado. At paragraph 93 of that ruling of 16th of October, you observed that we have no doubt in our mind, your mind was clear, my lords, that this matter raises issues of immense public interest. A matter that raises issues of immense public interest, we argue, is a matter that is infused with inherent merit. When you consider the ruling of your brother, Justice Chacha Mwita, at page 9, paragraph 3 in petition number 550, which is now before you. The judge observes, and I quote, "There is further argument that constitutional imperatives on public participation were not complied with. The petitioner has given an example of Keio South constituency to demonstrate this fact. According to the public participation results for that constituency, the total number of people who participated is given as 43. Those who are in support are given as 70. Out of 43 participants in a public participation event to remove Rigathi Gachagua, out of 43, 70 approved." My Lord, that's the case before you. This is how we have treated His Excellency Rigathi Gachagua, my client. Those who did not support were 3. They also got those who would not support. Having gotten 70 out of 43, there has some residue of 3 not to support. The percentage of those who support was 162.79%. We used to distinguish law and mathematics by saying that mathematics gives us instruments of mathematical precision. I don't know what the National Assembly will do with this mathematics, but this is curious mathematics. The judge then observes, it is implausible that an attendance of 43 people will produce 70 people in support and 3 in opposition. I submit that there was no remedial measure to this blatant failure by the Senate. There was no remedial measure. This poison has worked with this dispute throughout the process up to the time we come here. I'm making out a case that this case has inherent merit by these findings. At page 11, the judge referred this matter to the Chief Justice to empanel a bench on finding that the issues raised in this petition were immense. Again, that speaks to the inherent merit. When you look at the ruling of Justice L.N. Mugambi of 11th October 2024, all the way from paragraph 38 to paragraph 42, the judge highlights the matters of grave significance that this petition raises as a precondition to referring this matter to the Chief Justice. I submit that this speaks to the inherent merit of this case. And finally, at least for my part, when you look at the order from Ongoya in petition number E15 of 2024, which is before you, at order number 3, the judge observed that the matters raised in the petition, being of great national importance and urgency, he then referred the file to the Chief Justice. And I have 2 observations to make here. The finding that the matter was of great national importance and urgency speaks to the inherent merit of this case. If you look at order number 5 of the order of your brother Justice Mwongo, he gave the conservatory order because of the finding in paragraph 3, in order 3. He says, in light of the nature of the matters raised as noted in order 3, a conservatory order be issued. I want to submit to the nature of those matters has never changed. For you to vacate this order, you must convince yourselves, convince us, and convince the entire Republic of Kenya that the nature of these matters has changed. The matter has remained as it was on 18th of October 2024, which was the basis for the grant of conservatory orders. I therefore submit as follows: that because this bench, Justice Mugambi, Justice Mwita, and Justice Mwongo have, in the various rulings above, already found that this matter has inherent merit, it is not open to the respondents in their application for setting aside to invite this very court to revisit that matter and reach a contrary finding in the face of the principle of res judicata that you considered and applied on 16th of this month. I also submit that because the 4 benches I have alluded to have consistently found that this court has jurisdiction, it is not open to the respondents to argue that this court has no jurisdiction and invite this court to enter a contrary view without violating the principle of res judicata that you used against the petitioners on 16th of October. I trust that my learned colleague, Mr. Macharia, has taken note of the time and therefore he is able to compress arguments so that we pave way to the other petitioners. I urge that you grant the conservatory orders in petition number 565 of 2024 and in petition number 15 of 2024 at Kerogoya to preserve the subject matter and to give these parties a chance to ventilate themselves on the merits in the main petition. Over to Mr. Macharia.